can be made as clearly as possible. So whether it is in English or in Urdu, I think judges should write judgments in the language over which they have more command, and leave it to us as lawyers to explain the consequences of their rendering to our clients, which we have to do in any case. If it was in Urdu, I'm quite confident that I still have to explain the consequences of the judgment that a litigant has to bear. Thank you.
Well, thank you very much. Thank you very much indeed. You have very clear views on these matters. You have thought about them and you have worked for them. So thank you so much. Let me now move to Osama.
Dr. Naman, I have to leave. I would like to come back and join you once I finish this urgent business, because I'm really, really wanting to hear Justice Jalani.
Well, if you could come back, we'll welcome you, and while you're away, we'll miss you. So please leave, you must leave. Osama, in one of your interviews recently, you said exactly what Salman said. आपने ये बात कही थी कि judges are involved in a literary enterprise. You said that. In a way, it's all fiction writing. It's all. Somebody asked you, so why you turned to fiction, and you explained the relationship between fiction and language, and law and language. And in that context, you said that in a way, all law is fiction writing. I'm interested in these abstract issues, really. Could you elaborate on that?
I will try. We've had some very rich discourses so far. I think the element of sarcasm in my statement was perhaps missed when I said that the judges are also engaging in fiction writing. There is something called legal fiction, as we know, and there has always been an element of convergence when it comes to literary enterprises and legal enterprises, whether it's the appearance of legal figures in fiction as judges, whether you're looking at Bleak House or you're looking at Munshi Premchand or whatever, because law is such an integral part of human existence, especially in modernity, that fiction has been written around it, which is incredibly important to me. And then I think I have several points of convergence with Salman in terms of the use of language, the value of language, the commonality of the interpretive exercise, context, all those things. But I'm going to take a slightly different point of departure here, not by way of disagreement with what has been said, but to perhaps tweak and highlight a few other factors which are very close to my heart. So much as literature is incredibly close to my heart, I have come to the conclusion, while wearing the hat of an academic, and especially as a policy reform person, that the fictional projects and the judicial projects or judgment writing projects should be kept well separate from each other. And I say that for multiple reasons. I personally, first of all, think that one of the reasons I switched to fiction is, and that's what I was trying to say, there are a lot of things I can do in fiction which I can't do as a judge. I shouldn't do as a judge. I can be polemical, I can be rhetorical, I can be sarcastic, I can be cynical as a prose writer. I should not be any of those things as a judge. So I think a judge's task is much more circumscribed. It's much more governed by rules and parameters. That is not to say that whatever background reading provides flair to you or linguistic prowess, that is not useful. That is not to say that it cannot help you in terms of gauging context. That is not to say that if you read poetry and the message of empathy, the message of justice, which is embedded in a lot of great literature of the world, should not be inspiring you as a judge. I'm not saying that. What I'm saying is that when certain judges start imagining themselves as also producers of literary fiction and mingle that with jurisprudence, we neither have good fiction nor do we have good jurisprudence. I think judgment writing should be clear, plain, sparse, to the point. I completely agree with Hina Saiba on that point, because when as a lawyer or as a, so I'll quote this example, and Umar and I worked together on some empirical projects almost a decade ago, where we actually went and spoke to hundreds upon hundreds of people in the law courts and asked them about what, if anything, alienated them from the court system. And language was one of the biggest things, not only the fact that it was in English, that the legislation was in English, and much as a lot of rhetoric has been produced on the value of Farsi and Urdu, if the people who were at the helm of the affairs were actually sincere about access to justice, a lot more laws, a lot more processes would at least have been translated, or at least they could have done what New York did 25 years ago, which is to, enforce the plain English rule in a lot of the correspondence and a lot of the sort of corporate documents, other governmental documents. We use either a cliched colonial brand of English, and when we move to Urdu, it's a highly Persianized, difficult kind of. I think these are selected snobberies. I've heard judges addressing important seminars on criminal justice, which is in a dire strait, talking about Romeo and Juliet. I've heard judges and other sort of people in our system who are on a different trip. I love Hafiz too. I understand relatively little, but that's not the place, So I want to say this very, very clearly, that I feel that there has to be a huge emphasis as far as our judicial system is concerned and our judicial academies are concerned, where a lot needs to be done, where people need to be taught judgment writing. Even the fundamentals are not there, right? So unless somebody in an appellate court has a certain kind of a linguistic background, is quite well read, those are exceptions. But as a system, we don't do this. Now, the other point I want to make is that let us also not forget, and I have a huge amount of respect for the judges who stand out, and Justice Jalani is one of them, against the larger crowd in terms of their empathy, in terms of their clarity of vision. But let us not forget, as a constitutional historian, this is very clear to me, that our constitutional judgment writing and our history is an obscurantist history, right? So I've had to read 750-page long judgments, starting from the court of Hammurabi, going to the Talmud, and eventually arriving at why under Article 58(2)(b), the president can dissolve an assembly. I mean, this is nonsensical, if I may put it that way, simply because not only we have had so many discordant things coming out of all this obscurantism, these judgments, apart from all of multiple other things, are also riddled with poetry. When you can't explain something, you make it obscure. So I think that's a very huge problem. Then I think another example was mentioned earlier. When a political partisanship or a political sort of bias translates into sarcasm taking the shape of poetry, hugely problematic. The litigants, the people who are at the receiving end, and the citizens who are going to suffer because of that judgment are not going to be able to respond or retort, and a judge cannot be retorted to. And secondly, in subsequent decades, as students and lawyers sit down and interpret these judgments to try and figure out whether we have a direction or not, I don't want to be reading poetry. I want a very clear statement of the law, and judgment writing is actually governed by precedent, it's governed by rules, it's governed by legal interpretations. There is still a lot of leeway to do a lot. Mind you, this is also, I mean, we've still not mentioned the word post-colonial. We are in a post-colonial context, and historicity and context are both incredibly important to me. So we've had contesting traditions as well. We have strains of Islamic law. We used to have justice, equity, and good conscience earlier. We have influences of American jurisprudence, which is fine. You can create a very rich discourse around it. But it's not as if we have quite emerged clearly in terms of what the governing normative structure is. It is an ongoing process. So वो जो शुरू में उन्होंने एक मिसरा पढ़ा था ना, तो इधर उधर की ना बात कर. I actually subscribe to it, but I would say it in the opposite section. Instead of quoting that, इधर उधर की बात ना करें, बात करें आप मैं इसको 3 हिस्सों में तकसीम करता हूं. एक फ्लेयर है लैंग्वेज का, मुझे उस पर कोई इतराज नहीं है, as long as we don't fall into the pitfalls I'm talking about. There is also the entire intellectual nexus which Salman spoke about, which you speak about, which I completely subscribe in terms of an intellectual tradition. Ornamental, pe to zahir hai, we're all agreed we shouldn't have the ornamental, but I think the problem is even deeper than the ornamental, as I've already explained, and I'll wind up here. The problem is not just that the ornamental is used as the polemical, it's also used as the obscurantist. When you don't want to own up to a reality and want a certain outcome, you go for vague language, you go for long, meaningless historical conversations which are not even historical, and you use rhetoric which doesn't mean anything. And the other is that it is also used to take potshots, which is not what a judge ought to be doing. My humble, very humble sort of recommendation is anyone has a literary aspiration, whether it's a judge or an academic or a lawyer, publish a novel. Publish a bad one, that's okay. People can suffer selectively. So somebody doesn't want to read my book, at least that person can make that choice. But to the extent that I produce scholarship, if at all I do, or if I'm writing a judgment, I have to adhere to what are globally accepted principles in terms of brevity, in terms of clarity, and in terms of being forthright in terms of what you do. I'll stop there. And I've been deliberately a bit more, for want of a better word, belligerent about it, not because I have any disagreement with any of the worthy colleagues here, but because I'm reacting to my 2 decades of experience to what I've had to read. Thank you. Unmute कर लें, please.
Dr. Numan साहब आप unmute कर लीजिए kindly.
Asha, thank you so much, Usama. I have let me make an abstract point. It is perhaps useful to distinguish analytically between poetry and poetic process. Now, when a judgment is being written, the judgment writer is not writing poetry. He or she is writing a judgment. But then, while writing a judgment, there's a process of interpretation. And that process of interpretation can be a fiction. You understand a thing in a certain way, in a creative manner, and this is your own understanding of the matter. So there is a kind of a process of the moment of writing a judgment is also a moment of interpretation. What would you say to that? Is it not?
So I could be wrong. I mean, this is a speculation on my part, but I think that both processes are somewhat different. I tend to imagine that writing fiction and writing poetry, much as it's constrained by form and the rules of form and the rules of language, I think what we see by way of modernity and in terms of modern fiction, so many of those forms have been broken. The surrealist novel, the abstract novel, the magical realism kind of novel, I mean, oftentimes the plot conventions are completely demolished. That's true for poetry as well, which is not to say that there's no method to the madness, but I tend to imagine that as a process, aspects of which are still within the realm of the subconscious and within the realm of the unknowable. How does the creative process take place is not very evident to me, at least right now. How does a judicial thinking process take place is a lot more evident to me. If I were to write a judgment, or if I were to think that if Salman or anyone here were to write a judgment, there are constraints and parameters and gauges which we have to be cognizant of, right? So if there are clear precedents which are against what we want to say, because that's our contextual understanding or interpretive choice, we will have to very clearly, methodically, and scientifically distinguish ourselves and be able to address those precedents. I don't see those kinds of constraints and limitations in the poetic process. I find a lot more freedom there in some ways, right? It's the nature of the beast,
yes,
which is.
You know, of course, one cannot disagree with you. But then, even in writing poetry, there is some kind of an intellectual control. I mean, there's a difference between madness and poetry.
At times, they're difficult to say, though.
The control of forms, the control of meaning, the control of the social context, the control of the history of words. They're all part of that. So I'm talking about the process. You know, in the case of Ibn Khaldun, he presses grammatical issues and rhetorical issues into the service of jurisprudence explicitly. This whole notion of khabar and insha. This is very interesting. And I remember, I mean, a light-hearted point, as you know, that there was a controversy between Maulana Hussain Ahmad Madani and Iqbal. Iqbal wrote a Farsi poem, a small poem.
Surud Bar remember.
Ji. Yeah. Ajam Hanuz Nadonad Rumu Zedi Varna Zedioband Hussain Ahmad Chi Inche Bul Ajabist. तो बाद में इनकी सुलह हो गई आपस में. तो मैं बहुत छोटा था और मैंने पढ़ा उनका खत हुसैन अहमद मदनी का. तो उन्होंने इकबाल को लिखा कि देखिए जो बात मैंने कही थी वो खबर थी, वो खबर थी, इंशा नहीं था. I made no sense of that. खबर और इंशा का फर्क. इंशा में there is a normative, insha is something normative, kaisa hona chahiye. Khabar is simply a report, as Salman was telling us.
देखिए उस बात पे I can
say about hadith, this insha. Hadith is insha, उसमें एक अखलाकी पहलू है, कैसा होना चाहिए. इसलिए it cannot become a hujjat for history writing. So here
the example given earlier about the dichotomy, if anything, between sort of positivism in sort of jurisprudence and if you look at the Dworkinian sort of perspective, or if you go and look at somebody like John Finnis and the natural law school of people, ये जो एक डिबेट है कि जुबान को आप किस तरह से इस्तेमाल करते हैं और जुबान जो है उसमें आप कितनी आगे उसको कॉन्टेक्स्ट को कैसे लेके आते हैं, नॉर्मेटिव फ्रेमवर्क उस पर कैसे अप्लाई करता है, क्या वो सिर्फ पॉजिटिविस्ट है या नॉर्मेटिव है, एंड मल्टीपल अदर थिंग्स, इस पे तो बिल्कुल मेरा आपसे कोई इख्तिलाफ नहीं है. चूंकि जुबान के इर्द गिर्द और जुबान के इस्तेमाल के इर्द गिर्द जितनी बहसें फलसफियाना हैं, चाहे वो जूरिस्प्रूडेंस में हो, चाहे वो एपिस्टेमोलॉजी में हो, चाहे वो लिटरेचर के अंदर हो, उसमें ना सिर्फ ममासलत है, उसमें ताना बाना है, वो बात बिल्कुल दुरुस्त है. सो मैं 3 मुख्तलिफ चीजें कहना चाह रहा हूँ, इसलिए मैंने कहा कि इन चीजों पे तो मेरा पॉइंट ऑफ कन्वर्जेंस है बिल्कुल, और ये बहुत अहम है एक इंटेलेक्चुअल एक्सरसाइज के तौर पे जब हम जुबान को देखते हैं, क्योंकि उसके अंदर एक प्रोसेस है जिसमें सिमिलैरिटीज है. आई क्वाइट एग्री. दूसरा उसका जो पहलू है वो जुबान बजाते खुद उसका जो इस्तेमाल है, उसके अंदर जो फ्लेयर है या जो पॉसिबिलिटीज ऑफ लैंग्वेज है, क्योंकि ये फैक्ट है दैट अ मोर आर्टिकुलेट, अ बेटर रेड, a more philosophical person will likely make a much better judge, because you're not dealing with very simple things. You're dealing with social phenomena, dynamic societies, competing contestations amongst people. आपने इकोनॉमिक्स को भी बैलेंस करना है इसको. सो आप नैरेटिव लिख रहे हैं, उस लिहाज से कहानी की तरह ये बिल्कुल है, ये मैं मानता हूँ. लेकिन उसके अलावा जो बहुत से, लेकिन ये जो हम चीजें एक्सपेक्ट कर रहे हैं, मैं सिर्फ उसको प्रैग्मेटाइज कर रहा हूँ अपने जाती तजर्बे की बुनियाद पे, जो कि मैंने सिस्टम को बहैसियत मजमूई देखा है, वो सिस्टम जो कि जजमेंट्स प्रोड्यूस करता है. तो उस लिहाज से ये चीजें आइडियल हैं, लेकिन वहां पे जो है ना मसाइल अभी बहुत फंडामेंटल लेवल के हैं. वहां पे तो मसला ये है कि जो हमारा कानून का, तालीम का और फिर बार की ट्रेनिंग का निज़ाम और जो हमारी जबान की पे दस्तरस है, चाहे उर्दू अंग्रेजी हो या कोई भी हो, वो इतनी कमजोर होती जा रही है कि अभी तो वहां फंडामेंटल ठीक करने की जरूरत है.
जी जी जी. एक बात जिसकी मैं निशानदेही करना चाह रहा था और उसका मैंने जिक्र भी किया था कि one of the monumental intellectual problems in the history of Islam has been to turn it.
जी, डॉक्टर नुमान साहब की तरफ से